start. The prosecution evidence appears to have been put to the accused under section 313 of Criminal Procedure Code, whereafter, on behalf of the accused, defense evidence was adduced and all were got examined. Stop. The trial court, after hearing the parties, found all the four accused guilty of offence punishable under section 304B read with section 34 IPC, and convicted them accordingly. Stop. Muhammad Parvez Alam, husband of the deceased, was sentenced to rigorous imprisonment for 10 years, and each one of them remaining 3 convicts was sentenced to 7 years rigorous imprisonment. Stop. Aggrieved by the judgment and order passed by the trial court in sessions trial number 1219 of 2010, whereby the accused were convicted and sentenced, 3 appeals were filed before the High Court. Stop. Para. Criminal Appeal number 59 of 2014 was filed by Muhammad Parvez Alam. Stop. The High Court, after hearing the parties, allowed the appeal of father-in-law of the deceased, but maintained the conviction and sentence recorded against other 3. Stop. Hence, this appeal through special leave by sister-in-law Parwana Khatun and brother-in-law Muhammad Hassan. Stop. Our attention is drawn on behalf of the appellants to the testimony of the defense, and it is argued that the courts below have failed to appreciate the same. Stop. The cousin of husband of the deceased has stated that Parwana Khatun and Muhammad Hassan used to live in village, and on the day of the incident they were not in village, the place where the deceased and her husband used to live. Stop. We have gone through the judgment and order passed by the trial court, in which the trial court has mentioned the name of defense witnesses but not discussed as to why their testimony as to the fact that married sister-in-law and her husband used to live in village, is not believed. Stop. The High Court has also committed the same error. Stop. Apart from the above, in support of their plea, there are 3 documents filed on behalf of the appellants, which are copies of public documents, to show that they are residents of village. Stop. Copy of the residence certificate, which shows that subdivisional officer has certified on 31/10/2008 that he used to live in that village. Stop. Para. All public documents read with oral testimony adduced before the trial court, create serious doubt in the prosecution story, so far it relates as against the present appellants. Stop. We are not commenting on the evidence as against the husband of the deceased. Stop. In view of the above discussion of oral and documentary evidence, we find that both the courts below have erred in law in holding that the charge under section 304B read with section 34 IPC stood proved as against the present appellants. Stop. In our opinion, in view of the evidence discussed above, it cannot be said that it is proved beyond reasonable doubt that the present appellants, who are sister-in-law and brother-in-law of the deceased, tortured the victim for any demand of dowry. Stop. Para. In our opinion, in the present case, which is based on circumstantial evidence, it cannot be said that appellants had any common intention with the husband of the deceased in commission of the crime. Stop. It is sufficiently shown on the record that they used to live in a different village. Stop. Therefore, comma, we are inclined to allow the present appeal. Stop. Accordingly, comma, this appeal is allowed and conviction and sentence recorded as against the present appellants. Stop. They are acquitted of charge of offence punishable under section 304B read with section 34 IPC. Stop. They are in jail. Stop. They shall be released forthwith if not required in connection with any other crime.